present the bills, and then if the subcommittee chairs can answer any detailed questions, or I may turn it over to you. So first House bill, I'll call up House Bill 1155. This is, and I wanted to go really section by section. This went through subcommittee. If you notice, you have subcommittee recommendations. Okay. Okay. In short, what this bill is doing is if there's not a homeowners association, then there are, this provides a procedure by which a majority of homeowners can change the plats and the notes in there. And the procedure includes, thank you. The procedure includes a majority and then go into court, filing a petition, due process that has to occur. If you look in the language, certainly in section, let's see. You look in section 1 where it says homeowners association, the homeowners association trumps. You can't go around it. There's no homeowners association, then a majority of the people, of the owners, can file a petition in court, provide notice, present their case to the judge, and then address it from there. If there is no plat, then and somebody wants to do it, they can also do it through this procedure. I talked to the bill's author and he explained, which is what came up in subcommittee, is that really this becomes an issue with like 20-year-old, I guess, plats. And after 25 years, people can't change the covenants. It's not and so they wanted a procedure by which that can be done. I do know there's an amendment that we have brought up in subcommittee. I'm calling it the Diamond Head Amendment. Is that right? Senator England, I'll recognize you for the amendment at this time.
Thank you, Mr. Chairman. Yeah, I think that's fair. It's a very simple amendment that after lines 138, you'll have another subsection 4 there that says the provisions of this section 2 shall not be applicable to in any municipality located in a county where Interstate 10 intersects with the Jordan River. So again, I think it's probably appropriate to call it the Diamond Head Amendment. And it's my understanding after talking with folks in this area that there's not only pending litigation, and we're not certain this area would be affected by this bill, but we're just trying to make sure that we've got that in there for that community that's got this case ongoing in the Court of Appeals, I believe, at this time. As a matter of fact, I think it's multiple cases, but that's the amendment. It's just to add that in it.
And I'll state this on the amendment. Diamond Head, for those that don't know, it was probably one of the first planned communities. It's down in Hancock County. It's very detail oriented, so to speak. And so there was some concern, and like Senator England said. So are there any questions on the amendment? Do I have a motion?
If no questions, I'll move for adoption of the amendment.
All in favor of the amendment, say aye.
Aye.
All opposed? Okay, the amendment carries. All right, we're on the bill. Any questions on the bill? Senator Bear.
Yeah, thank you, Mr. Chairman. So if there's a residential neighborhood that hypothetically I moved into this neighborhood without restrictive covenants, they can form some sort of or HOA and then adopt restrictive covenants. If I'm in that neighborhood and oppose those, I would have to take that challenge to court, correct? Is that what this is doing?
No, nothing from what I understand the bill and having read it and talked to the sponsor is there's nothing to prevent anyone from doing an HOA. Okay, so that would all, however that's done, that stays the same.
Okay.
The only question is when, after years goes by, that if they can't, somebody it changes or wants to change it, then they go to court to do that. And the problem that's being done is they're there for 20 years. Like you said, somebody moves in, you know, the plat has covenants on it and the neighborhood's changed, all that. And right now you can't do anything. And this allows a procedure by which that can happen.
I understand. Thanks.
Senator Blackman.
Thank you, Mr. Chairman. Secondly, that the covenant have X number of years that they are valid for, and then once that expires.
I don't know that. I default to somebody who practices land. I don't know that.
All of those that I have seen. And they'll say 20 years, 30 years. That's when they can make changes, matter of fact, just went through the text.
My understanding is whatever's been filed with the plat, that's what governs. And so, but I don't know of any specific time limit on any of that. That's outside my knowledge.
But we develop subdivision and put in.
Okay.
That third fire. And the home. Right. That's the person that's developing and stuff. And it's been a lot of time, money, and effort, and they want it a certain way. And that's why those developers that's want to have their vote.
That's right. And the bill sponsor has said, I agree with you on that. And they're saying after that period of time, the issue is that it's changed, things have changed. And so this just allows for a procedure to be put in place.
Thank you.
Thank you. Any other questions? I have a motion. Motion's House sufficient do pass. All in favor, as amended. All in favor, say aye. All opposed? That carries. Thank you. All right, House Bill 1157. You have the strike all. This is, we passed our bill. This is the rental car, vehicle rental and disclosing the charges. The only difference or the big difference between our bill and the House bill was that our bill had the consumer protection language. And so we put our strike all in there with the consumer protection. So there's an enforcement mechanism. So with that, have any questions?
What is the important?
The consumer protection law that's already on the books. Any questions? All in favor? Oh, I'm sorry. Do I have a motion? Motion's title sufficient do pass. All in favor, say aye. All opposed? That carries. Thank you. House Bill 1218, Rivers McGraw. I think everyone's familiar with the mental health courts that we have done. And this is an update to that coming to us from AOC. And you can see the language in there. This is to bolster up the mental health courts to provide that they're actually doing what we set them out to do. I will say that it's, as it matures, we find out these things. And so this is simply adding into, you'll see the different definitions and what those mean. And that's coming to us as a result of what they're seeing and trying to get the best possible court system for our mental health courts. So any questions on that? Do I have a motion? Just title sufficient to pass. All in favor, say aye. All opposed? Okay, thank you. Go to House Bill 1342. The original bill deals with adoption. The strike all before you, proposed strike all, is the Senate irretrievably broken bill that passed the Senate 44-5. Adoption's important. It's extremely important, but so is getting families out of laws made by us that are being weaponized and that are holding people in situations that literally are against families. And so that's what the strike all is doing is, and of course, it'll go to conference with the idea that maybe we can get something for both adoption, which is the task force, and that we can get some relief for families, and in particular, women who are in these marriages that we're stuck in. And I will say this, that the House has not moved our divorce, the irretrievably broken bill. So here we have it. Any questions on that? I have a motion. Motion's title sufficient, do pass committee strike all, sorry. All in favor, say aye. All opposed? Okay, thank you. I'm actually gonna skip over for right now, HB 1216 and go to 1149. We'll get to Senator Boyd in a minute, but the short of this is that 1149 is the path to permanency requested by CPS as a result of our hearings that we had, how to get our children in the best way possible through the system. And but the language similar to this is actually going to be in 1318. There were some differences. So what I'd have a request for a reverse repealer in this. Okay, so we have a motion for a reverse repealer. Any questions on the motion? All in favor, say aye. All opposed? That carries. Okay, we're back on the bill. Any questions on the bill? Do I have a motion? Motion title sufficient, do pass as amended. Strike all in favor, say aye. All opposed? All right, that carries. Thank you. House Bill 1318. This is again part of our Women and Children Subcommittee, or the Standing Committee, I guess. And I'm going to turn it over to Senator Boyd for that.
Just procedurally, we were actually, when we had our subcommittee meeting the other day, we were meeting with the youth court judges, and we thought we had all the changes documented when we presented the committee sub. We did not. We left out just a few when we were doing that before subcommittee. So I am going to ask you to vote against adopting the committee strike all and go back to the original bill. And then you have a new bill in your package that has all those changes incorporated. So then I will go back and ask that you adopt that committee. So
Okay, so we're on the committee substitute. You've heard the motion to vote against it. All in favor, say aye. All opposed?
no,
No. Okay. So now we're back on the original bill.
all right. And what I'll ask you to do is look at the strike all that's before you right now. And that, and I will go through the strike all that's before you right now.
This is here. Okay.
I'm sorry.
Okay, so you're saying we voted against strike.
The committee strike all, and now you
The
have
subcommittee strike.
subcommittee strike all.
So I'm sorry, I didn't explain it. In subcommittee, they did a strike all and adopted the strike all. Since that time, there's been some other changes that Senator Boyd has worked on. And so the motion that we did was she requested that we vote down the committee's, the strike all put in by the subcommittee. So now we're back on the original bill, and she does have before you a proposed strike all that that incorporates the subsequent changes.
Okay, so it's what in the package, the subcommittee strike out that we voted against, or this is the committee strike, this is the new thing. Okay.
Thank you. I'll go ahead and explain the strike all, and then I'll ask permission to adopt that strike all. And the strike all, just to tell you, like we did the legislation the other day, y'all had a number of comments in committee and about the procedures that we could use here. We had a number of comments from the youth court judges across the state. Again, I want to thank the youth court judges for assigning a committee to us to work with us. Judge Stacy O'Neill from Madison County and Judge Stacy Bowles from Lee County came down here with CPS attorneys as well. And we worked through all the various different issues. And so what you have before you is those changes and their recommendations that we've incorporated in that process. So what the bill does is it's broken down into two main parts. It has a safe haven law and then has a clear path to permanency for children who are in CPS custody. The first comprehensive safe haven law that's to be used in conjunction with our current baby drop-off laws. Sections 1 through 5 increases the time frame for parents to surrender their children from 7 to 30 days. And a child may be relinquished to a hospital with ER, a fire station that's staffed 24/7 or by an ambulance. And if the parent cannot travel to one of those locations, they can call 911 if they're unable to travel. The bill goes through what emergency medical providers are to do in those instances where children are relinquished to their care. Once children have been relinquished to their care, law enforcement is tasked with doing an investigation to make sure the child is not a missing child. CPS promptly will publish notices in the paper where the infant was found and relinquished with newsprint and broadcast media to follow, and that anybody, if they want to insert parental rights, what there's to do. We also then worked with, there are some existing laws within our statutes already that we felt like was a better way to do this instead of outlining completely these separate laws, working with the youth court judges. We found out maybe there is some lack of misinformation with the youth court judges and the procedures that they can follow to do this. So we're going to use the procedures that are already outlined in that section. In section 6, we clarify that a child alleged to have been abused or neglected should be a priority in those proceedings before the court, and how the court should appoint for any child an attorney for indigent children. And then we also, which is a very important thing, is make CPS the necessary party at all stages involving the child. And this is something that's not presently done. And CPS asked for this, particularly in light of the Olivia Watt case, to make sure this is done. We've added CPS as a list of the parties that are entitled to get notice by the court when there's been hearings. We amended the current membership of the Mississippi Commission and youth court judges to include 2 employees from CPS that the governor would make. And then we directed the commission to submit a support to the legislature and for October 1st. We amended current laws to state that the court clerk shall give priority to TPR cases on their docket so that we can further speed along those TPR cases. And then we did conforming legislation and some legislation that we passed last week. To waive home study requirements. And so we narrowed this down to a step parent or relative or foster to adopt situation, that the chancellor would have the discretion, the judge would have the discretion to waive home study. The chancery court exclusive jurisdiction over all adoption proceedings except when a county court is sitting as a youth court has required jurisdiction of a child in just abuse and neglect proceedings. And then we have asked the chancery and county clerks to set priority of those cases on their docket. And then finally, in section 13, we added testimony and exhibit of items that should be confidential and not subject to disclosure in adoption proceedings. So that is kind of a long list of everything that we've done in this piece of legislation.
Thank you, Senator Boyd. You worked hard. We're on the strike all. Do we have any questions on the strike all? Senator Turner Ford.
Thank you, Mr. Chairman. I was trying to scan the bill. Where is the provision? Did you mention a publication?
There's a publication provision.
And I can just state my question. My question is, what would be provided in the notice that is published?
The notice basically sets forth that anyone who That was something that we originally had here, that I will ask to, let me move to adopt the strike all in and then amend that strike all to include that notification provision. If I can do that. Yes.
Okay.
Okay, well,
Yeah.
I'll make the amendment first, and it, we have a notification, provision in there that, you would notice it required notification of all. I'll tell you what it did. It required to publish notice in the newspaper in the area where the input was relinquished, as well as send a news release to broadcast and print media stating the circumstances under which the input was left with the provider and the date, time, and location of the court hearing. And the notice should state that any person wishing to assert parental rights must do so. Notify CPS, and also for relinquishing a party identified another parent, notice has to be sent to them by certified mail to the relinquished if they were given notice.
As I understand the bill, the mother is not required to disclose her identity.
She is not required to. That's right.
And so the notice, if it's amended and incorporated in the committee sub, it's just going to say that a baby was dropped off at X location on X date and there's a hearing.
And there is a hearing, and that if anybody would have it concerning parental rights, should notify. Yes.
Would there be any real way to know if rights can be asserted, or there's no identifying information regarding the child
Right,
or the parent that surrendered the child?
right.
Unless they chose to get that.
Unless they've chosen to give that to the court, they would not. I mean, there would be situations like with the baby drop off, where just they are asked to give any information about the other parent, about the father, those situations, but just like any baby drop off situation. So, this actually going a little bit of a step further because it is. Trying to make sure that the natural father are in that.
Thank you.
And if there's any last minute address that just happens to be given, that requires certain amendment, that last minute address.
So, Mr. Chairman, I would move that we adopt that language.
Okay, you've heard the motion. That's the amendment to the strike all, correct? Okay.
Yes.
Any questions on the amendment? All in favor, say aye.
Aye.
All opposed? Okay, we're on the amended strike all at this point.
Yes.
Any questions on the strike all? Senator Blackman?
General question. Are we still, in federal,
Yes.
with judge, about all the different changes that we are making?
I will, and I'll let Senator Boyd add to this, but this bill, along with the other ones that have come before us, have been brought in a big part to us by CPS. Also during the hearings that we had in the Women, Family and Children Special Committee, we heard that, and these have been proposed to us with the idea that this will, I guess, take some of the pressure off on the Olivia Y lawsuit and will make us look more favorable to them. Is that right, Senator Boyd?
Yes, Senator Blackman, I believe all these changes, like, once the legislature makes those, so the commissioner will be informing the monitor. Because we have a monitor in that court case, and she has been working very actively and aggressively with the monitor to, so these were a number of changes that are brought and encouraged to us to do by CPS, who has done a great job with the monitor, really kind of working through a number of our issues.
So it's the monitor and in your fees.
The monitor has not been EFA's, but Commissioner Sanders has a great working relationship with that monitor, and I think she's probably communicating everything with the monitor at this point.
Thank you. All right, any questions on the bill? Do I have a motion?
Motion.
Your Senator Boyd moves title sufficient do pass strike all as amended. That's your motion? Thank you. All in favor, say aye. All opposed? Thank you very much. All right, you have, if you will go back up to House Bill 1216. Just a little background. This bill, as it came to us from the House, is the office allowance for judges. And also contained within there, well, it's the office allowance and for, in particular, for staff that they have. So I'll tell the committee that I've been working with Chairman Hobson on this. It is, and I don't know, I'll say it again, even though I've said it before, we will do redistricting, court redistricting next year. And it's our anticipation to do it as much as we can at one time. So with that, we were hoping to do this bill then. However, through a very strong lobbying campaign, and after I spoke to the Chief Justice, who's a very good advocate, and he did explain to me that much of this money, or in fact, all of the money, goes to staff in our courts, that makes our courts run, and the judges. It's not lost on me that the judges have received 2 raises over a certain amount of time recently, but this is going to the staff. And what I've also, Vice Chairman's gone. I've also had brought out to my attention that court reporters, for whatever reason, are not being paid like they should. And if you remember, a couple years ago, probably a few years ago, there was a back and forth on court reporters getting raises because whatever regulation or ruling came down from the Supreme Court, they couldn't go out and seek additional employment. And then there's places across the state where the supervisors have refused to fund their court reporters. I've had different judges tell me that they would do it themselves. So what I would like, if you have before you a strike all, and the strike all, the difference just on the strike all itself between that and the original bill is on lines 22 of the strike all. It's raising it from 9,000 office allowance to 15,000. And then in lines 59, it's going from, and I'll explain this, currently the total that the judges have are 80,000. The House bill that's sent over, they sent 140,000. Well, I saw the pro tem's face. That was my face as well, Mr. Pro Tem. So the strike all before you is 100,000 total. Which is, we also have another bill that I've been working with Senator Hobson on that we passed, which is the DAs, and there's an office allowance and we raised them by 15,000. So this is about in line with where we are on our DAs and prosecutors on that. The other big difference on the strike all is that in the House bill and current law, it specifies where that money is to be spent. The Senate strike all is saying, we're giving you the money and you can spend it in your discretion, and that's up to you. So if you want to pay your law clerks, you can do that. If you don't, that's on you. So that's the strike all. And then what I would ask for an amendment is in lines 18. That we strike out the word no, capitalize P. And in line 19, change the word shall to may. And so that would read, part of this expense or allowance may be used to pay official court reporter for services rendered. So we have that's moved. Everybody heard that. All in favor, say aye.
Aye.
All opposed? Okay, and then, and so just to, if you look again, just to, I guess, repeat, go back over at line 59. The House said 143,000. Our amendment, the strike calls is 100,000, which is a 20,000 increase, which is in line with what we've done. I will say this, that with redistricting next year, this will be, let's just say, remembered. And it is, in speaking with Senate Chairman Hobson, with the Lieutenant Governor, it is the Senate's intent to redistrict based on data. And this was part of, we don't have all the data, but it's on the data. And most of the people I've talked to believe we need to do it. We need to do it because it hasn't been done in a long time of a significant. And what that means is there are places that no longer have the caseloads that they had 30 years ago. And just like we dealt with the DAs, they all wanted one when there's caseloads that don't necessarily justify them. So the Senate is committed to doing that. I've spoken with Chairwoman Cockerham. I've told her where we are, and she agrees on the data part of it. So that's where we are in this. So do I have any questions on the amended strike all? Senator Black.
Thank you, Mr. Chairman. Now, this $100,000, is this is for all of their support staff?
Yeah, the current law is they're getting 40 and 40, which is 40 has to be spent on, on support staff, and 40 on law clerks. And we're saying in the strike all before, use 100,000 and they can spread it how they want.
So they can have a secretary that can law clerk.
Yeah. And
But the court administrator, don't they share those.
right. If you look at subsection 1, it says office operating allowance, and this is current law for expenses of operating the office of the judge, retaining a law clerk, legal research, so forth and so on. And then subsection 5, support staff shall receive compensation. So that goes to, I would argue that's the salary portion. Any other questions? Senator Turner Ford.
Thank you, Mr. Chairman. So what is at line 22, from 22 to 24, the $15,000? What is that? It says office operating allowance.
Right, that's what I just said, the office, to operate office. Research, I'm sorry, legal research, stenographic help, stationery, stamps, furniture, all that language above that.
That's what's the
Yes.
$15,000 is
Right.
allowed to cover that.
And on line 22, that said 2008. And so this was a point that was made apparent to me that this hasn't been changed since 2008. So it's where we are.
And but let me just ask my question, I guess, as relates to all of these expenses. Will any of these expenses have to be borne by the counties?
Based on the language I see here, no, but I don't know if there are county expenses. I don't know how that works. Okay, you heard that from the
I did not.
appropriations chair. So there are some counties that do pay on that, yes. Okay. Any other questions? Okay, so we're on motions title sufficient do pass, strike all as amended. All in favor, say aye.
Aye.
All opposed? Motion carries. All right. Thank you very much. Appreciate it. Rise and report. Now, let's get out. Now, that one has to go to appropriation.